Joining us from the American Prospect and also, I think, from the Intercept, Rachel Cohen, Marcia Brown. Welcome to you both. You guys have written an incredible a piece in the Prospect with the help of the Intercept on that question of how Democrats can deal with a court that seems to be hostile to just about everything that I think a lot of Americans take for granted that the government can do and take for granted in terms of like laws that have already been passed. Rachel, let's start with you. You cite the example of Lilly Ledbetter. Just quickly tell us that story so that we get a sense of the concept here.
Yeah, so Lilly Ledbetter, and thank you for having us. The Lilly Ledbetter Fair Pay Act, which maybe people listening to the show might remember, was the first law that Barack Obama.
Sorry. We're having problems with your internet for some reason. I think we're having trouble with connection. Marcia, are you there?
Yeah, can you hear me okay?
Yeah, we can. Let's Marcia, why don't you answer that question for us and we can see what's going on with
I'll try switching to my phone and you can go.
Okay.
Sure. So yeah, thank you very much for having us. So the Lilly Ledbetter Fair Pay Act, which passed in 2009, was the first piece of legislation that President Obama signed. And it was actually a response to a Supreme Court decision, which Justice Ruth Bader Ginsburg wrote in her dissent was very parsimonious and was really kind of nitpicky. And in her dissent, she said, the ball is in Congress's court. And so she actually called on Congress to clarify the language in the statute because effectively, the court had said that, okay, yeah, there might be some pay discrimination here, but your statute of limitations has expired because the clock began counting when you were hired, not when you first realized you were experiencing pay discrimination. And so Congress updated the statute of limitations, and that was all it took for that to essentially nullify that Supreme Court decision.
Okay, and you guys have outlined a whole multiple silos, essentially, where there are some key rulings that Congress could overturn. Part of this is really incumbent upon what happens in Georgia, although you do cite a couple of places where you have bipartisan, I guess, opportunities. And Rachel, why don't we start with you on that? What are those bipartisan opportunities? What areas and what specific laws do you think that we can look to perhaps a gang of four again or a gang of eight dealing with Supreme Court rulings?
Yeah, well, I can answer it, and then I'm actually going to let Marcia speak a little more specifically to antitrust because that is one of the areas, and she wrote about that specifically. But I think you're right. Obviously, our judicial overrides will be easier if Democrats reclaim the Senate, and we think that this is something that the party should be making more clear to voters in terms of laying out what's at stake. It's not just Supreme Court nominations, it's actually the ability to override bad Supreme Court rulings too in this upcoming runoff. But we do also think that even if they don't win, there is still opportunity to overturn bad decisions, and there are different legislative ways people get individual things through. But, historically, there have been judicial overrides, bipartisan judicial overrides in civil rights. In 2008, there were a bunch of overrides passed to the Americans with Disabilities Act. So that was bipartisan. We have had times in the past where voting rights and civil rights were more bipartisan. And we think antitrust is another area that could be possible area for compromise. Marcia might want to speak more to that, though.
Yeah, Marcia, tell us about antitrust, because I have to say that I am a little skeptical about the prospect of bipartisanship. 2008 in in human terms was not that long ago. In terms of like where the parties, particularly the Republican Party, has gone, it seems like a half a century ago. But tell us about antitrust.
Yeah, I mean, like you said, in 2009, Democrats had the House and the Senate, so it was a different time. But I think what is important to think about with antitrust is that there's the Democratic majority in the House Subcommittee on Antitrust came out with a 400-page report where they actually identified, I think, over half a dozen Supreme Court cases that would be important to overturn to strengthen antitrust law. And Ken Buck, a Republican on the committee, released a response called The Third Way. I think he called it The Third Way for reform, where he actually identified some areas where he thought there would be some bipartisan agreement. One of those cases was Ohio versus Amex, where there might be some room, American Express, where there might be some room for collaboration on that. And just to add to what Rachel was saying, these overrides can be passed as legislative riders, so you can attach them to sort of unrelated bills in the House and the Senate. So there are ways to do it without passing it as comprehensive legislation, but a number of the overrides that we've identified are actually included in several current pieces of legislation that are more comprehensive that have already passed the House, and some that haven't passed but have been proposed. So there are different ways to pass them, but like legislation, you do need to have some excitement, some push behind it.
I want to get to some of the other silos, but and I don't know which one of you knows the history best about this, but why do you think this changed? I mean, you write that during the 70s and the 80s, even into the mid 90s, Congress would, and we should say, up until that time, the House was dominated by Democrats. I mean, and so there was never any question of the Democrats not controlling the House at that time. Occasionally, you would get the Senate. What changed in terms of the disposition of legislatures and their relationship to the court?
Yeah, well, we a lot. So there are legal scholars who have been sort of trying to figure this out. And we talk about some factors. There's not like one clear answer, but it's sort of a number of things were going on. So some legal scholars say it's just that Congress got more partisan, more polarized. And I think people agree that's obviously played one factor, but it doesn't really explain everything, because Congress was pretty partisan and polarized in the 90s when they still passed a bunch of judicial overrides. So, and another factor people cite is that the decline in overrides also, there has been a decline in congressional staff. So when you have less capacity in Congress on committees to be doing this kind of research, a lot of Congress members just sort of outsource things to outside advocacy groups now. As they lost their own internal capacity, that could have been a factor. But we also make an argument about Democrats specifically, which is just like there has been a mindset. There has been sort of a relative inertia about treating Supreme Court cases as like the end of the road, the final step there. Like, and we see that in just the way the reaction to our piece has sort of showed this. Like most people, this hasn't been a way of thinking about bad decisions. It has on the right, and conservatives like often talk about this, but on the progressive liberal side, if the Supreme Court weighs in, the response from a lot of liberal lawmakers and progressive advocacy groups has been to sort of be really upset and frustrated, but not talk about, well, how can we now mobilize and organize a law to override it? And so we're sort of making the case that this tool was used by Democrats for decades, and we can use it again. And for some, we need to get back in the mindset of recognizing that this is a legal and important way that to represent the separation of powers and for Congress to exert its legal authority. So we're sort of trying I don't know exactly why they dropped that mindset, but they did. And so we're sort of trying to say, like, we need to pick that back up again. It
seems like it's consistent with a general lack of, I guess, exertion of will by Democrats that we have seen. There is a temerity that has existed since that era. And frankly, we have the leadership we still have today in the Democratic Party. They all came in during that era. And when so I suspect that that's not a coincidence. Let's talk about reproductive rights, Marcia. What is your sense of what the court can do there? And like I say, folks should really check out the piece, because there's you have a whole slew of these silos of law which they can be changed. But let's just start with reproductive rights. What can the court do to strengthen reproductive rights in this country? I mean, excuse me, the Congress can do.
Rachel wrote about reproductive rights, so I'd want to pass the microphone to her for that.
All right, Rachel, tell us, please.
Sure. So, one thing that I say in the piece about reproductive rights is there's a lot of political momentum that if Democrats reclaim power, what they really have been talking about for a long time is overturning the Hyde Amendment, which is the law that bans any federal funding going to pay for abortions. And so this is not to detract from that. It's just to, to put out that there is more that a, active, proactive Congress could do. And so one of them, the case that we talk about, you may recall the 2014 Supreme Court case, the Hobby Lobby case. And that centered around a law from 1993 called the religious
RFRA.
RFRA,
Yes,
Religious Freedom Restoration Act.
Yes.
And so basically, civil rights groups, advocates, religious freedom groups felt, argued that RFRA was being manipulated and distorted from its original intent in that Hobby Lobby case as a way to deny people from access to contraceptive services. And what Congress could do to not only address that case, but future attempts to use RFRA in negative ways, because it is also being used to deny non-Christian parents adoption. It's being used to deny transgender patients' rights. Like, it's sort of being used in a host of different ways. And there is a bill in Congress right now called the Do No Harm Act that was introduced last year. And it would basically tweak and clarify the RFRA statute to basically preempt any future lawsuits of that kind if it would prevent harm to a third party. So it's sort of a sweeping way to get at all the different sorts of ways that RFRA could currently be used to deny reproductive healthcare or other services to people on basis of religious, things.
Marcia, did you work on the environmental law?
Yeah.
Okay, let's talk about that, because one of the things that I know there's a concern about is that this court in particular is going to deal with things like the Chevron doctrine and the idea of the delegatory power of Congress. In other words, for folks who, and I'm disappointed if my audience isn't fully aware of both those doctrines, but the idea essentially that the courts and Congress can delegate to, let's say, the EPA, you figure out what constitutes clean water and you do the steps that are necessary to make sure that we have clean water. We're just going to say, pass a law, we want clean water. And courts generally would defer also to the EPA. How can they deal with, in what you write about in terms of what Congress can do to fix those things? What can Congress do to sort of inoculate some of these protections from a court that is determined to revisit Chevron and this delegation authority that Congress has?
Yeah, I'm really glad you bring that up. The Chevron doctrine is really critical, both when it comes to environmental law, but also in other areas of the law, because it is about deferring to an agency's interpretation of the law. And so where we've seen that in the environment is where the EPA kind of interprets the law kind of expansively to include greenhouse gases as an air pollution, and therefore they can regulate that. And so there have been several cases where this has come up, and the EPA has said, okay, we're going to regulate emissions because of greenhouse gases because they're considered an air pollution, and then the court will kind of temper that. And I think what's really important to think about when it comes to these to this area of the law, but also to the larger thesis of our piece, is that this is a way for Congress to take back power. And from the court, where we always kind of think of, the liberal activist justices, but actually a lot of conservative justices are pretty activist when it comes to something that might have been considered settled law, like the Chevron doctrine, that they're now kind of bringing back up and thinking about actually, how are we going to reinterpret this? And so there is some worry there. And I think a lot of environmental scholars are also worried that if Congress takes up any kind of comprehensive environmental reform, that it could actually come out more watered down than it is now. So despite the fact that Congress and the agencies are working with statutes, some of which are 40 years old, passed during the Nixon administration, some of them have been updated, but not very many. The EPA has actually been able to kind of stretch those statutes through the Chevron doctrine. So it's going to be really key for the Chevron doctrine to really maintain its strength so that the existing statutes can be used. But some scholars do think that there is areas to tweak around the edges, and even if there isn't comprehensive legislation where that could open a can of worms, these kind of statutory overrides would be an option for Congress to clarify the language. So the Clean Water Act is a really big one. Actually, what happened with the Atlantic Coast Pipeline this year, that was also one where they could just clarify the statute, and then the pipeline wouldn't have been able to get a permit to cross the Appalachian Trail twice. And there's also ones where different agencies offer different permits, but sometimes the kind of pollution doesn't fall into either of those permits. And so then the corporation will argue, well, we don't really need any kind of permit regulation. We can just do this. Or if we have one, we're fine. And the court kind of says, oh, okay. So there are ways to clarify that and strengthen some of our environmental protections through these overrides.
This may be outside of your portfolio, but is there a way for Congress to protect something like the Chevron doctrine? Is there a way for Congress to protect its ability to delegate authority, or are these constitutional questions that Congress can't really mend?
That's a good question. I would say that that's probably a little outside of my expertise. I would ask a legal scholar that question. But I would say that, and this is something we bring up in the piece, these statutory overrides are a way for Congress to directly intervene, for a Congress to take back power, to clarify the statute, update the law, which is really a classic thing to do. I mean, the environment changes, the pollution changes, and so Congress needs to update the statute. That's just that should be considered regular lawmaking. But conservatives have never shied away from, I don't really like this court decision, and so we're going to fight back against this. And the Roe v. Wade 40-year battle has been a great example of that, where it was a constitutional decision. Congress couldn't really act on that, but conservatives could have this grassroots movement where they cut back and tempered that decision. So it would be great for liberals to take up a cause that they think is really important. I think Citizens United is a really great example of this, where it's a constitutional decision. Congress can't overturn the decision or nullify the decision, but Congress can write laws that temper the force of it.
Right. We see conservatives do this, like you say, on the question of choice, where we have states across the country where a woman's ability to have an abortion is effectively gone. And these introductions of these so-called trap laws are also equally problematic. Rachel Cohen, Marcia Brown, the piece is in the American Prospect, How to Counteract the Court. It was done in partnership with The Intercept. Thanks so much for your time today. I really appreciate it.
Thank you.
Thank you.